Okay, hi everyone. My name is Olivia Lee, and this is Judy Moncrief, and we are your HR specialist at Clear Employer Services. Um, we are getting started. I'd just like to have make sure everybody puts their phone on mute or their presentation on mute so that we can proceed. I don't know. All right, hold on. Let's see. You have everybody on mute?
I think so. Can you hear me?
I can hear you. Yeah, good. Okay.
Oh.
We're going to mute.
Okay.
Okay. Okay. So thank you for joining us. We are discussing the New York Paid Family Leave Act that has recently passed, and actually it's still a little bit in flux, and it's causing a lot of issues because they're making some suggestions about how to proceed, and we just wanted to give you some information about what we have and what we plan to do here at Clear. So a little bit about the paid family leave. So paid family leave is just exactly what it sounds like. In New York, you already, yes, have a short-term disability for your employees that is mandated, state mandated. You also have the sick leave, and this is in addition to those two laws that you need to comply with. Paid family leave will give your employees the opportunity to take off for FMLA-related issues, events. Yes, thank you. In order to take care of the family, or specifically, not themselves. So it's going to start on January 1st of 2018, and the main stir up is that they are requesting or suggesting that we start taking payroll deductions on July 1st, which is coming up this week. So we want to go through that information for you. So part-time and full-time employees can participate or are mandated to participate in this program. The one type of employee that's not are public employees that work for the government, but they can sign up to do that. Those agencies can agree to do it. And then also employees who are temporary employees and seasonal employees that would not be able to, throughout their expected term, they would not reach 26 weeks of employment. So those employees then would not be required to pull the deductions out of their pay. And so this is just going over that public employees are not covered. So employees, in order to claim this insurance, employees are required to notify their employer. They do want employees to give 30 days notice in advance. And normally certain life-changing events like the birth of a child, military deployment, or some type of surgery, especially if it's something that you can schedule, you should be able to know as far as advance as possible and give your employer notice. And we did talk about this already, is that for full-time employees, they have to work for 26 weeks with you, and then they're eligible. And part-time employees, they actually have a different type of eligibility, and it's about days of consecutive employment, so 175 days. All fun to track on our end at Clear. So employees, and it's also extremely very similar to FMLA. They can return to work after their leave without their loss of benefits and anything that they would have accrued as far as like paid time off. The one thing that's really important is that the employer must maintain their employees' health insurance coverage during this time. So if you are committed to and contributing 50% of the employee's health insurance, you have to continue to contribute that 50% throughout their time on leave. Now, the caveat is that if the employee does not contribute their portion, you could terminate their benefits and send them out COBRA during that leave period. But so you both need to maintain those things. Okay, so paid family leave, and it's just really, definitely does run similar to FMLA. So in a rolling 52-week period, they can take out their maximum benefit, which we will cover. I have a chart coming up next. So once they take time off, even if it's intermittent, which would mean every Tuesdays and Thursdays I have a doctor's appointment that I need to go to for my sick child, even if it's intermittent, that rolling period starts from the time that they start using the benefits. So the law states that we will have 4 different tiers each year of moving up into a full maximum benefit. So the full maximum benefit will be take place and start in 2021. But for the first, we're easing into this. So for the first year, starting January 1st, 2018, we will start with the availability of 8 weeks time off with the maximum benefit of 50% of New York's average weekly wage, which is currently $13.05.92. So what that means is that anybody who makes more than $13.05.92 in a week we will not, I guess, tax that amount over that amount. If they make less than that, then you don't go up to the maximum. You just tax on their current benefits, and the tax is 0.126% of their pay for that week in a week. So this also caps the benefit that the employee can receive. So they can only receive up to 50% of their weekly wage up to the New York State's average weekly wage rate. So that's how much their tax is based off of that and how much money they can receive. And it's 50% for the first year. And then the next year in 2019, it goes up to 10 weeks available that they can take at 55%. And then the next 2020 is again 10 weeks, but then we go up another percentage to 60%. And then the ultimate goal of the law is that in 2021, it'll be 12 weeks that they are available that they can use, up to 67% of the New York State average weekly wage. And this amount will change every year, so the benefit will fluctuate. We have no idea how the percentage will fluctuate, but the benefit will.
And we understand it's one of the richest disability or paid family leave programs in the nation at this time for the state of New York.
Okay, so we hinted on this a little bit, but I want to go over the reasons why you take family paid leave. So maternity is a big one. It's bonding for the birth of a child or adoption of a child, caring for a spouse, a domestic partner, a child, a parent, parents-in-law, grandparents, grandchildren with a serious health condition, and we'll go over what conditions those are. And then this is also very interesting, but I think poignant option that they're giving is for people who have active duty and deployment, and it's not for yourself, it's for caring for your family members. So if you have a husband who's deployed or a wife or a child who's deployed, it helps to relieve the stress when you have a loved one who is on active duty deployment. And so here, the serious health conditions are physical injuries, impairments or disabilities, mental conditions. Sometimes it's hospice, residential care, continuing treatment, sometimes like oh God, I just forgot. What is it when you keep in physical therapy, things like that. There will be forms and information that they're going to send out. I think once we get closer to, it'll be state regulated once we get closer to the first of the year. Things that you cannot take time off. So if if I want to get a nose job and my husband wants to take care of me, no, that he cannot take off to take care of me with my rhinoplasty. But, if there are any questions clear, we'll stay on top of that, and we will definitely be a resource to you to help determine what your employees can or can't take off for, and help you with this. One of the things that's really important to realize is that when a spouse works for the same company, you both can't take off to take care of the same sick or disabled relative. So if you are both under this benefit, is what I mean. So can an employer allow both employees to be out? Absolutely. Maybe one spouse will take their paid time off, PTO, and the other spouse will use this benefit, but they both can't use the benefit at the same time if they're employed at the same organization. Okay.
But if they work for different employers,
yes,
they can do that.
Correct.
They
Yes.
could both be off at the same time, one from each employer.
Correct. There are, the amount of documentation that is needed for each specific to prove, I guess, each specific health condition or the reason why you take off, it's pretty vast. So you just know that you can't just write a note and saying, my daughter's sick, I'm taking off. This is not what we're doing. We're having serious health injuries and conditions. So there's forms for the government for deployment. There's forms for FMLA and your healthcare provider to figure out who you're going to, if you had a birth of a child or adoption of a child, there's plenty of forms. And so we would just have you contact us and let us know what the serious condition or the reason for this using this service or this benefit. And then we will provide the correct forms and help each employee fill out the forms, and then CLEAR would fill out the employer portion of those forms. So a lot of people are going to ask questions about what we're doing with paid time off and PTO. Paid time off is a benefit, and this is not related to New York sick leave law or other disability laws. This is only for paid time off, and the New York employer can designate whatever they want to do with the paid time off. They must be consistent and communicate with their employees about what they're doing with PTO or vacation, whatever you want to call it. So if you can require, and we could put this in handbooks and things like that, but we can require that employee that is eligible for paid family leave benefits and has accrued unused vacation or personal leave, you can choose whether or not to have them charge their paid time off or not. So you can require they take paid time off first, or a portion of their paid time off first, and then use the family leave benefit if they want. You have your choice of what to do. Because there's no regulations right now, you can't, I guess, you're not compelled to make them use their available FMLA, their available benefits under FMLA. You're not compelled, but you can. So it's your choice until they make some kind of regulation, and you get to choose.
Yeah, I'm not sure if under this law right now, similar to the FMLA, that if you utilize your PTO, it's running at the same time as your paid family leave.
It is.
So it doesn't extend the paid family leave. However, it may reduce the benefit. So if you're receiving paid time off and you choose to do that as the employer and require the employee to, say, use 10 days of their PTO as part of their paid family leave time, it could reduce their benefits for those first 2 weeks.
Right.
So it's really a decision on your part as to what you'd like to do.
Mm-hmm. Correct. So sometimes employers choose to pay for some of these types of, give money for maternity leave, or, when employees are out for disability, they can choose to pay for up to a certain amount of time or up to a certain amount of weeks. If you do that, then under this act, you are able to recuperate some of the funds that you pay out to your employee from the insurance carrier, for the family leave insurance carrier, which will be the same as our disability carrier. And so just under FMLA, the same thing is that once the employee returns back to work, then they are reinstated to the same or a similar position, regardless of which option you choose on this card. Okay, so, oops, I'm sorry. So again, what we're saying is that this does not add time. It runs concurrent with FMLA and other related laws. So it's just a monetary benefit that gives employees rights to take off when they need to care for a loved one. So, all right. So they have something set up about denial and appeals. And basically what that means is that someone could submit all the forms and then be denied the benefit. If that happens, we will work in order to try and help employees through. Maybe paperwork was inconsistent or something like that. We will do the things that we need to do on our part. We also will notify the employee for you, so you can be removed out of that process, because we at CLEAR would work that out for you. So what will CLEAR do? And a lot of our clients have been asking us about, when do we start? What do we do? What's next? There are so many regulations that have not been set yet. There's still so many unanswered questions. I've been on the phone with some of the lawyers for the disability. And in the state of New York, I've been talking to our insurance carrier, which is Guardian, as you all know, for New York State disability. I've been really searching for some of these tools and answers. And I think after, discussing with the leadership here at CLEAR, because there's so many unanswered questions, we do not feel comfortable moving forward and taking money from employees without some of these questions answered. The benefit is still going to be applicable for your employees starting January 1st. And from the statements from both lawyer and from our insurance carrier, that they do believe that regulations should be solidified within the early August. So it's only 1 month difference from when they suggest you start taking money out and versus when we plan on starting. So we will get all the regulations solidified. One other thing that we have a small issue with is that the insurance carriers do not have a policy created yet. So there's no place to put the money that we collect from the employee. So it is very important not to be holding on to money that we don't have a place to put it to as well. So we want to be very responsible and respectful for the employee, because it is employee paid benefit. So as the product finalizes and the laws finalize, and we do get a policy from the insurance carrier, then we will then communicate to our clients and roll out our plans. Okay, so I'm going to unmute everybody. And then if you have any questions, you can let us know. Anybody?
Olivia, this is Fran. How are you? Question. If this is going to run concurrent with FMLA, does that have to be disclosed early on to the employee in writing? Is that?
Yes, absolutely. So thank you for that question, Fran. One of the things that we're going to do is, once the regulations are created, I know a lot of our clients have gotten new handbooks recently and they're concerned. We can't put this policy into the handbook before it's actually law. So a memo is the best option once we roll out and determine what's next. The memo is the best option. So we will create a memo that can be edited by you or any of our clients, and we will have all that information and disclose to the employee what is happening for their benefits. All right, just so you know, you're all unmuted. So if you're moving around, anybody have any other questions?
Did that answer your question, Fran?
Yes, thank you.
Yes. So the other question is, they suggest you start collecting in July, but you don't have to.
Correct.
and they think by August we should know when specifically we must start collecting?
So technically, you must start collecting January 1st, 2018. But the because it's employee paid, and the state does not want employers to have to use any of their own money, they would allow collections to start as early as July 1st. The collection is to then pay the premium once a policy is created. But until we have a policy created, we don't know what the premium would be. We don't know how far in advance or how much we need to collect for the employee. And currently, our guardian collection is monthly. So if it's monthly, then we wouldn't need to tax our employees. It doesn't benefit us. We don't get to keep the money. We give it all to the insurance carrier. So why frustrate your employees with not being able to answer questions and collect funds from them when we don't have anything to give them? I mean, I think that's not anything that employers would want to do.
Do you have the option of not having it go through Guardian and have the employee deal directly with the state? Because I know New Jersey does that for their paid leave. You don't have to have it. If you have your disability with a private company, your paid leave, which is very similar to this program, you can still have the employee still deal directly with the state. Is that an option for New York?
It doesn't seem like it, but I will ask this question because I have my plan is I have a meeting with the lawyer, a virtual meeting with one of the lawyers I was speaking to at New York State Disability Office. And I will ask them this question and then report what I find back. But it doesn't seem like it. The one thing I did find out is that employers can choose to pay this benefit for the employees.
So being that and the employer can start it, and then the employer can start later on to take the deduction from the employee, right?
So, can you
if
repeat
they
it?
choose to pay for it? If the employer chooses to pay for it, they don't have to start the deductions until January if they decided to?
The employer can choose to pay the benefit. But the New York State is making the policy so they don't have to. If they choose to pay, you can deduct from the employee, but that makes it a little convoluted, I think. So I feel like it should be either or. You can deduct from the employee or you pay. The employer holds the policy, and that's I think the caveat, similar to what Fran was just saying about can the employee deal directly with the state. It doesn't seem like it here, but I will confirm. You're not required to take money out now. So if you don't take money out now, if you don't take money out until January 1st, that's fine. But starting January 1st, you need to have a policy and it needs to be funded or have some money going into the policy, not fully funded. I don't want to say fully funded. I'm sorry.
So Olivia, hi, it's Michelle. I have a question about that. So if we choose not to fund it until January 2018, can we let you guys know that don't take it out in August or September, that we want to wait till January? Is that an option?
I can't answer that, but I will email you offline. So one of the things, we are the employee on record. And so once we get a policy created, what we would suggest to our clients and what we are going to do is to tax our employees as least as possible, but not strain our businesses, if that makes sense. So if once we have the policy, we can't say what will we do or not do. Once we have the policy, then we can move forward with a plan. But we don't want our employees paying into a policy that doesn't exist. And we don't want our businesses having a lump sum of money due January 1st. So our goal is to combat that by making like all the points line up at one time in a perfect point. So everybody comes at the same time and we're taking the right amount at the same time. It's not taxing the employee and it's not taxing our businesses. Does that answer, Michelle?
It does, but if the employer chooses to not do because it sounds like if we charge the employee the few months before, then that's because the employer doesn't want to advance it. But let's say the employer is fine with paying the bill, but it's still going to be deducted as of January.
Right.
understand what I mean?
I do. Unfortunately, I can't just say for sure until we get the policy from our insurance carrier. But we will work with you to do the thing that you feel is best for your company.
It's just hard, I think, to tell people that the fund is going to start coming out, but they can't use it till January because they're
Correct.
going to see it coming out of
Yes.
their check, and they're going to be like, "Why can't we use it?" And we're
Right.
saying, "Oh, we don't want to pay it in advance, so you can't."
Right.
Right.
Yeah, I
just
mean,
wanna know
in my
if-
opinion, we don't want to start taking this benefit out until
Everything's finalized.
and the latest possible time, because you're right, the employee does it to pay. So who knows how close that'll be, but we will. Here's an example. If an employee can use the benefit starting January 1, but they can't use it, we might start it, in December 1st. Who knows? I can't say for sure until they give us a policy and tell us how the funding works. If they say we need quarterly billing, then that would be different. That's could be, thousands of dollars that then we'd have to collect. And we don't want to tax the employee and we don't want to tax the employer. So we're going to really hope to make it as close as possible to everybody paying this as close to the deadline as possible to get the maximum benefit.
Do you know when's the deadline for the policy to be finalized?
They don't have a deadline, and that's another annoyance. From my understanding from the lawyers is that the law is going through public opinion polls, and so people are commenting on what's going on with the law, and then they will take, starting this week, all of the opinions and finalize the law. And when they finalize the law, a bunch of communications will go out. And we are on it. I'm on a news blast from the lawyer's office. We're paying attention. I'm on the phone with our guardian carrier all the time. So,
yeah, it's been frustrating for us also when we've called for answers and, we get told, well, we don't know yet.
Yeah, but
So
they really feel like, from what I hear from the lawyers, they think that it will take about 2 weeks to collect all the public opinions and go through them, another 2 weeks to finalize the law. And so that's why we're predicting early August for finalization. And then the insurance carriers 100% are waiting on the law to be finalized because they need those regulations in order to start giving us policies.
Do you know if Guardian bills in arrears or in advance?
They bill in advance, so we pay at the beginning of the month for the full month.
Got it.
That's for disability. And another small issue. I feel like I feel comfortable saying it's going to be similar, but there's no guarantee, unfortunately.
Okay. Got it.
Yeah. So the other thing too is, it's very important to realize it's the smallest company, one employee, the smallest company. And so we do need to educate our employees about this. And it's very important because if you are a very small company and you only have 5 employees, you have to still participate in this. And your employee could technically take off for 8 weeks if they have a qualifying event. And this could be difficult. So it's really important to start thinking about how writing standard operating procedures and making a way for employees to communicate what they do on a day-to-day basis so other people can, cross-training and things like that. So this is just what I would recommend to get prepared, especially for the small organizations.
Olivia?
Yes, hi.
It's Carolyn. How are you?
Hello.
Hi. Quick question. Is this just for New York employees that work for New York clients, or if you live in New Jersey and work for the New York client, you still have to pay?
Yes, you still have to pay. So it is for New York employers,
Wherever you can.
Well, what if you're a New York employer, but your employee works in Georgia?
Yes.
They still have to pay? Can they
Yes.
use this benefit?
Yes.
Yes.
Wow.
And I mean, New Jersey has a very similar plan.
Yeah, we
Right,
have a
but in
client we have a client in New Jersey, and there's a New Jersey, it's called FLI, it's Family Leave Insurance in New Jersey. And we have a client who has employees all over the country, and they do have that benefit available to them.
Yeah, but there's a paid leave, which, so let's say you go out on maternity leave, okay, on the New Jersey short-term disability, even if it's with a private carrier. If you want the paid leave, the New Jersey paid leave, okay,
Mm-hmm.
you have to be a Jersey resident.
No, that's not correct.
The Jersey family leave is different than the Jersey paid leave.
Correct. New Jersey disability, short-term disability, and family leave is different than New Jersey FLI, Family Leave Insurance, which is a paid leave.
Right.
And we have multiple employers in New Jersey who have multiple employees in different states. They may be a New Jersey-based company with employees in South Carolina, California, Nevada, and those people can take advantage of the benefit. It's coming out of their pay.
So, I mean, and then I want to keep it New York, though.
Right.
One of the things, too, is that I didn't mention this, but I do want to. If you're like a second job for an employee, or maybe they have a second job, we can't tax them twice for this. So it's really important to ask employees if they have another job in New York, so that we're not taxing them twice for the benefit. Just important for that. And I'll add that to our new hire booklets.
I have a question about that, because that's a question we haven't asked before. What if they have 2 part-time jobs?
Yeah, it's
Right.
tough. I mean, these regulations, 26 consecutive weeks or 175 days of your part-time work. You have to ask, is it seasonal? Is it seasonal employment? Do you know if you have the benefit taken out? You might have to ask them to show you their pay stubs. I mean, in confidence, of course, but just so we can help them so they don't get taxed twice, because you can't take this benefit if you're having a baby and you work for Dunkin' Donuts and you also work for, I don't know, like Dell, Target, whatever, and you can't take the benefit from Dell or Target, or you can't take the benefit also from Dunkin' Donuts. You only can use one time. So, are there any other? I've heard some FAQs here, but I think I covered them all.
It's another reason why we don't want to start the deduction so soon, in addition, because if we start to take it out and then the employee leaves before January 1, 2018, they do not get refunded.
Yeah. One other thing too, I just read something, and this is important for people, especially I think a lot of people on maternity are taking care of sick parents and things. So if you're on maternity, this leave does not start until you actually have a person to take care of. So anything that's happening before is disabled on the mother. And when the baby is born, then you have a person to take care of, and then you can apply for this. So your mothers who
bonding.
Bonding
For a newborn.
So if you're on bed rest because you're pregnant, this is not family leave, which is different under FMLA, right? Because FMLA you would be able to do that. So just definitely don't discriminate against people. I just have to say, don't do it.
It's bonding for a newborn, but also bonding for an adopted child.
Mm-hmm. Yeah. Okay, so if you guys have any questions, you can definitely email us, myself or Judy, or the general email, HR support at clearpeo.com. And we will help you all through this. And trust me, as soon as we know information, we will deliver it to you ASAP. Okay? All right. Well, thanks everybody for their time, and thank you for hanging in there with us. We appreciate it.
Thank you.
Olivia, is it possible to get copies of these slides that you had?
Absolutely. I'm going to email the presentation and the slides, and we have also a little worksheet for everybody too, or like a guide. for everybody too.
Okay.
What we know right now.
All right, thank you.
Thank you so much.
Thank
Thank you.
Thank you.
Bye.
Bye, everyone. Good job, Liv.